Welcome back. Well, the conference has since ended, and so we're going to look at some of those highlights and recommendations of the NBA conference, which held this week. We've got Mr. Paul Ananaba, Dr. Paul Ananaba, Senior Advocate of Nigeria, on my immediate right. We also do have Professor Richard Wokocha, who is an Associate Professor of Public Law with the Rivers State University and also Chairman of NBA Omoko branch. Immediate past, beg your pardon. Thank you, gentlemen, for coming on this morning.
Yeah, thank you.
Wow, what a session that was, and some highlights from the NBA there. But what were your thoughts when those who went on? Let me start you, Mr. Ananaba.
No, I mean, thank you for having me first, and there was nothing unusual about it. That's the firepower you get from the legal profession. And for some time, we've not got a successful convention or conference like this. This is about one of the best we've had. For those who have been attending for the last 50 years, they say this is one of the best. So because of the fact that as at now, NBA is, has found its rhythm and is back to what it used to be.
Are they actually back?
Yeah, we're back. You could see that. And then because of the reforms, we had to go in to reform ourselves. I'm not saying we are at the best point, but we've left Egypt a long time now.
But you heard what they raised in that report. I mean, the issues, the back and forth. So if you say the NBA, is it in terms of participation or the firepower? How do you mean it's...
They're all part of it. You see, when your house is not in order, you cannot talk about issues of public... And I give you an example. I'm saying that because I'm chairman of NBA section of Public Interest and Development Law.
Okay.
And over time, NBA didn't pay much attention to this section. And that is why what you saw was a plenary of public interest and I mean rule of law. We would have been discussing maybe certain internal issues. We are now bringing the content of public interest forward in our meetings.
All right, Prof, what do you think? What was your thoughts when that happened?
First, I think I found it interesting, but I'm beginning to get a little bothered because I think we are devoting too much time to matters that are clear. I do not see the basis of the seeming differences we are having. The law is clear on these matters, and I do not think we should dwell so much, spend so much time debating what should not be debated.
Okay. What we will do, we'll come back and take a look at what is clear, or what legal aspects are clear about it. But we've got our correspondent, Ibrahim Adra, who is on the president's crew. He did travel for that particular trip to Japan. Good morning, Ibrahim. It's morning here anyway, but could you go ahead and tell us, so where are you at the moment and what is going on?
Well, as you can see from behind me, we are at the press conference center here, the International Press Conference Center, set up specifically for TCAT 7. Like I did sent in earlier on, TCAT 7 has come to an end. It ended about 3 hours ago. I was declared closed by the host, Prime Minister of Japan, Shinzo Abe, who commended the level and quality of discussions amongst African leaders and other global players at this conference, and said that all he hopes, his parting words when he was leaving the hall, was that he hopes to see productive and meaningful outcome following discussions in the last 3 days. Altogether, 6 plenary sessions were held with different thematic areas of discussions, and President Muhammadu Buhari was in 2 of those plenary sessions. So yes, it has come to a close, and the co-chair, who is the Egyptian President Mohamed El-Sisi, on his part, his parting words were that the African market is now open for business, and that African continent will provide a conducive climate for doing business.
You know, when they keep saying about, Africa market open for business, from that, what conversations went on either on the sidelines or directly in terms of how we, the country, Nigeria, will be internalizing and operationalizing some of those recommendations there at the conference?
Well, what came up, let me also quickly let you know that at the end of that conference, there is a declaration called the Yokohama Declaration, as well as an action plan. So perhaps the question you're asking, you will find a lot of the answers in the action plan, which is to a large extent very technical at this stage. But what came to the fore and was very obvious is the need for Africa to embrace innovation and technology, which is what Japan is known for. So I guess the leaders are going away knowing that they require a lot of technology as well as innovation if they are to solve their development challenges, especially in terms of infrastructure and processing and manufacturing, which is key to development.
Now, in terms of some of the issues that came up, how strong did Nigeria seem in negotiations, trying to table some of our, can I say, demands? How strong did we seem in that end? Did we seem as though we had, a lot of power trying to, get perhaps more investment into the country?
Well, maybe power is not the right word to use here, folks. What was important was that from all indication, Nigeria came prepared. It knew exactly what it wanted. It knew in what areas it wanted to seek investment in. Mr. President, in his speech when he delivered it, mentioned key areas that were of priority for Nigeria and asked that people come to invest. And not only that, he also went further to say what it is his government will be doing in terms of encouraging and providing that kind of atmosphere. That includes removing, in his words, every impediment that might stand in the way of investment. And then, again, most of these discussions happened behind closed doors. The details were not known. But at every forum and at every opportunity, the Nigerian delegation has asked loudly too that they would want to see more investment in Nigeria. And in fact, all of the leaders in part of the declaration when they were leaving was that they do appreciate what TICAD has done since its inception in 1993. And they appreciate the innovations that have come on board, the development that has occurred. And they only wish that more of such will happen, of course, with the caveat that it has to happen on their own terms to a large extent.
All right, then, Ibrahim, we appreciate your time. I understand you need to run. So thank you very much indeed, and well done.
Well done, guys.
All right, so there you go. Let me come back to you, Prof. You were saying that some of these things, the law is very clear on, because they were talking about the action and inaction of the NBA and some lawyers concerning Onnoghen. What is it that is so clear to you?
First, the issue of whether NBA acted or did not act will arise from the situation whether an abuse has occurred or whether the law has been breached or violated. Now, the subject we are discussing is what happened in the case of the last CJN before the current one, before the current Chief Justice of Nigeria, that's Honorable Mr. Justice Onnoghen. If you look, the law determines who should exercise what power and in what circumstances. And if you look at Section 153 of the Constitution, it establishes both the NJC and the Code of Conduct Bureau. To the NJC, it gives the power of screening persons for appointment and disciplinary matters over judges. Disciplinary. And then to the CCB, in the same section, the Constitution gives the power of determining the question whether or not, in handling the question whether or not anybody has breached the Code of Conduct. And in that provision, as you will find in Schedule 3, it says if it appears that an allegation has been made out, that it should refer the matter to the Code of Conduct Tribunal, which is established in Schedule 5. Okay,
now we need to go to a break, actually, but we'll come back. Let you conclude your thoughts in terms of what transpired, and then we'll have Mr. Ananaba weigh in as well. Stay with us. All right, welcome back, Prof. Go ahead and conclude your thoughts, please.
Okay, so basically, what we should look at to determine whether NBA was missing in action or not is whether there was a wrong. And there will be a wrong if the CJN was removed in a manner that is contrary to the provisions of the Constitution.
You don't think that was the case?
That was not the case. The entire drama was over suspension, pending investigation relating to his action.
So suspension cannot be
Suspension and removal are not the same. A suspended officer remains the officer. An acting CJN was appointed. Somebody was appointed to carry out the duties of the office, but he remained the CJN of Nigeria. So he was not, even at the end, he was not removed. He resigned. He resigned at a point when petition had been written to the NJC, and NJC had investigated the petition that was written to it and was going to make a return to the president. And he resigned. So there was no point at which he was removed. And the presumption that removal and suspension were the same thing was what led to this whole drama.
So why then were there publications by even some members of NJC that the processes were not adhered to?
I was talking about the processes earlier. There was a question whether the Code of Conduct Tribunal had competence to try the CJN.
Yeah.
Remember that you were not talking of matter of indiscipline. You were talking of breach of the Code of Conduct, which the Constitution says is exclusively to be handled by the Code of Conduct Tribunal if the Code of Conduct Bureau refers it to them.
We'll talk about what was this breach in the first place, but Mr. Ananaba, please.
Well, I don't know whether Prof was at the Code of Conduct Tribunal. I was there. I was part of the legal team, so I understand what I'm going to talk about. But what we were discussing at the conference, even from where you came, is not about interpretation of laws. You know, this saying that they came for the communists, I said I was not a communist, came for the trade unionists, I said I was anti, nobody was there. When we talk about public interest issues that now came to the fore in this conference, that is the issue we are discussing, really. We're not going to go into as many lawyers as possible will be on the either to defend or to prosecute. I mean, that's what we are trained for.
That's what lawyers do anyway.
So if from the academic perspectives, the laws are there and all that, but the judges may have different. But you can have 5 judges and they give 5 judgment opinions. So there may not be any time laws are settled. In fact, if there was a court after the Supreme Court, they would have appeals. So now, what am I trying to say? We're looking at the gains of this conference. I was there in 1992 when MBA began to have the problems. And we have not really got it right until we arrived here. Well, my brother is saying that nothing went wrong. With due respect, I don't agree, because even the Court of Appeal has said so, that the procedures were not followed. If you permit a situation where, by an ex parte order, and the timing of the day when it was made, a Chief Justice of the Federation will be removed by a Code of Conduct Tribunal.
So are you equating removal with suspension?
Oh, sure.
Or is it the same thing?
It is discipline. It is of a judicial officer. And I'm going to explain why I don't agree with Prof, with respect. The Code of Conduct Tribunal, is it a judicial institution or an administrative institution? Is it within the executive or within the judiciary? Those were the issues. The members of the tribunal, the Constitution did not say whether they must be legal officers. It's just the chairman that must be a legal practitioner of some year, at least 10 years. Now, that is where you have left to say, and the tribunal, the Code of CCT, was ruled that they are answerable to the Secretary to the federal government. And you are saying that it was right, even when the Court of Appeal is saying it wasn't right. So what we are trying to say is that, where was MBA when all these were happening? What position did they take or did they not take? So going forward, because of the public interest issues that have arisen now, you will now see NBA actually having a position in the interest of the nation. That's what we're saying. Not about public interest issues we're not talking about in NBA. It's not about antagonizing a government. Where the government does well in the interest of the nation, NBA should come out to commend the government and instill confidence in the government and governance. But where the government, or the institution, security apparatus does not do well, they will now remember that the NBA is likely to oppose this. You have to check and then you are having constitutional amendments. You have all kinds of issues going on. NBA does not say much then. That's the issue. That's why Femi Falana was asking, this man, what happened to him? Remember, judges have been the security agents had gone to judges' houses.
Sting operations.
The sting operations. And not much was done by him. That's the issue.
But speak to this impression that people have, when I think Mr. Falana was trying to allude to that, the perception that, judges have monies in their accounts that cannot be explained and things like that. But that those who would think that there's corruption amongst judges and that maybe the bar, was trying to protect them.
Let me just, we resolved at this conference that we will never protect any lawyer or judge that is found wanting. And the legal profession has never at any time condoned that. That's why we have our internal mechanism to deal with both the lawyer or the judges. Now, just for me to go weigh in a bit and then I'll get my brother to talk. You see, the issue of the CJN was not about corruption.
What was it about?
It was about code of conduct. And that's why he went to code of conduct. The code of conduct tribunal does not try corruption issues. There are courts for that. So that is why some of these media hives does not help. Because the public may not get to know the real thing. The CJN had to go to, had to be arraigned before CCTV because it was a code of conduct issue for which Section 3, the professors of Section 3 sorted out that since he admitted, there was no point. But now, you are now bringing to say, oh, he was arraigned and the order was made because of anti-corruption. If it's anti-corruption, it would have gone to the appropriate tribunal. And when you are carrying the corpse of another person, it's like wood, the stone or wood, until it is your time.
Right. It's interesting that 7-8 months after this first came up, we're still hearing about it. And I'm sure we've not heard the last of this. But some will say this is a high-profile case. That's why we're getting this sort of, almost unending response to it. Okay, I know you want to quickly butt in. What do you have?
Yeah, it's true. It's a high-profile case. It's not just a high-profile case. It's a peculiar case. It's about the Chief Justice of Nigeria. But I think part of what has made a lot of lawyers to take positions they have taken is the issue of Section 3 of the Code of Conduct Bureau Act. That section says something that is contrary to what the Constitution says. And for me, it is elementary law that Section 1, subsection 3 of the Constitution says any law that contains any provision that is inconsistent with the Constitution is, to the extent of that inconsistency, null and void. Issue of Section 3 does not arise at all because the Constitution says where investigation reveals that there is something to answer, Code of Conduct should refer it to the Code of Conduct Tribunal. The Bureau should refer to the tribunal. So the act saying where the person admits, let him go, give him the form and let him fill and go, is providing something contrary to the Constitution, and that shouldn't be debated.
Professor Wokocha, let's take a look at something that might hit home with a lot of Nigerians. Yes. Now, we've talked about this fact being a peculiar and high-profile case, but let's look at what affects Nigerians. A lot of people still experience, arbitrary arrest, harassment. We have rape cases. I can go on and on. These are things that people can relate with. It's something they see every day. So the question is, people have said that the effectiveness or the quality of rule of law in any country depends on the proactiveness of the
Of
bar,
its lawyers.
of its lawyers.
Yes.
What we're seeing in Nigeria today, and looking at the conference you've had, what is the way forward? How are you going to tackle this for everyday Nigerians?
This is why I began by saying that I think we were dwelling too much and spending too much time on what was not supposed to be a serious issue. We should be...
No matter how peculiar the case is.
No matter how peculiar it is. Because we have serious issues we should be tackling now. Now, the peculiarity of that case and all that borders on these sections of the Constitution and conflict with an act and the Constitution that we have talked about, which is, by virtue of the provision of the Constitution, Section 1, Subsection 3, not an issue. It's resolved. We should be dwelling on what to do about these matters you have mentioned now. The bulk of our energy in the conference should have been channeled towards how to deal with these issues to ensure that the future that we were looking at could be better than the present in which we are discussing it. So this is where the bar needs to do something. This is where we needed to brainstorm on how we can improve the security situation, what policy changes need to be made so that we can come up with recommendations to government on policy changes that need to be made to ensure that the security situation is improved. Okay. Those should have been our responsibility.
Well, please, I don't know. I was the co-chair of the content committee of the TCCP, I mean, the conference. So I mean, we'll talk about, I mean, there were 9 sessions on public interest. It's never happened before. That's a credit to this administration of Paul Osoro. You see, we now got a conference where the sections provided the content and not just somebody saying this is what we're going to discuss. And public interest and development law was my section. I was the chairman of that section. And we brought it. You would have seen that the chief of army staff sent 3 major generals and a retinue of soldiers. The Navy was there, and all the ICPC was there and all that. That is what we were talking about. We now began to talk. And going forward, the section on public interest and development law is being mandated to move on these issues. Issues of public interest. We didn't go there to discuss the CJN. It was just an aside. Somebody raised, I mean, Sekome, and you know, that's part of, those are part of hot conferences. You know what lawyers should be discussing. But then there will be in the coming days a strategy session on law enforcement and public interest, and then we'll move on to the main conference in Aba on November 6th. And then we will set the tone, supporting the government where they are right, and telling government, these are your boundaries.
All right, let's get Markwa in here. Let's see if he's going to go public interest or with the peculiar case. Markwa?
Well, I think it's a bit of both, because I did hear Mr. Ananaba say that, you know, one of the resolutions they reached at this conference is that they would not cover any public official or any lawyer who is found wanting. The question is it found wanting in investigation or found wanting by a court of law? Because, you know, the question is, when will the NBA come in and say this person has been found wanting, and so we will not protect the person? I think that, for me, is the first question. I'm trying to remember what the second question is, but let's handle that first, and I'm sure the second question will come.
Fine question. It was also part of what we discussed at the conference. You see, the NBA, the profession has its own internal mechanism. You know, the Bar Council, the disciplinary committee, the body of benchers and all that. Each they have their roles. Now, in the recent past, we've had issues because there have been 2 Supreme Court decisions on discipline of lawyers. So as of today, we have 902 petitions against lawyers. We will not go to put it on the pages of newspaper. Investigations go on and prosecution go on. What we are talking about is not that. We are talking about media trial. Before you know it, any simple thing is already in the media, it hampers investigation. We are saying, if a lawyer is found wanting, there are rules of professional conduct petition, investigation. It goes to the disciplinary committee. Then the person the issue is addressed according to the law. Just like a soldier. If a soldier has an issue, it won't be done on the pages of newspaper. There is the court-martial process under the Armed Forces Act. Same with the police. And then for a judicial officer, it goes through the NJC. We've seen judges dismissed. What we do not agree with is a situation where, money is found in this person's account, it's on the newspaper, the person is already accused before everywhere, one another. If you look at other crimes, they can be investigating you for 6 months, going through. They pick you, evidence is available, you are prosecuted in a few days' time. Some of these judges' matters are still pending in court till now. Now, when that happens, cases the judge may have been handling are stalled. You are not moving forward. You are not moving backward. We are trying to look at public interest in all this.
So, Prof, you think this is public interest reporting or is media trial?
No, I do not think it's media trial. It depends on the point at which media is getting to hear about it. If a profession like ours and the other professions that Leonard Senior Advocate has mentioned, if such professions notice something and they investigate quietly, they will do their work, and before the public will hear what has happened, they've concluded what they are doing. But if the profession is getting to know at the same time that the prosecutorial law, the state authorities are getting to know of it, we cannot say that the law should stop until the profession finishes what it wants to do internally, unless it is something that the law exclusively vests jurisdiction on the profession. In this kind of matter that we are talking about, NJC has no criminal jurisdiction. It cannot try crimes. Neither can it investigate crimes. It does not have the tools for forensic investigation. That's on one hand. NJC, by virtue of the provision of the Constitution, has no competence to determine whether a person has breached the code of conduct. That has to be determined by the appropriate authority, and NJC can act on the outcome of that determination.
About if the NBA, if the bar is going to take or comment or take a position or weigh in at any point in time, what is their thinking about when others will then think that they, or people watching, will expect naturally that should be the line that people should toe or lawyers should toe, or that should be the line or the position of the law on that particular matter?
Well, if you believe a legal practitioner had done something wrong, let me use that loose language, your best bet is to petition the person. But you see, where I caution against certain things like the public gets to know and all that, investigation is even hampered by publicity. Let's often remove lawyers out of it. There should be investigation. You can be investigated and you don't know you are being investigated. Even you, talk less of the public. This race to, publicize all these things has not helped us. Look at what happened in Ghana. Judges were, private journalists, investigated judges, and they did not know. And then the journalist was able to get information. What we need is patriotism and integrity. A lawyer must have integrity, must have patriotism with him. And the profession must also be an epitome of it, so that people have confidence to say, if I report this lawyer to the profession, they will look at it dispassionately. Also, you must have strike a balance with that and frivolous reports. I give you an example. A senior advocate was reported by the rules of
My apologies. I understand we need to go to break, but we'll come back and hopefully get your example. Stay with us. All right, welcome back. It's our concluding moments now on the program. And gentlemen, this is, I believe, is a public interest, which is what you think or say that we should focus on. That is what has been missing. Let me even read this. Yes? Now, the IBA president.
Yeah, what's that? What I should say, all of us are activists.
Okay. Now, we understand that there was a report on bullying and sexual harassment in the legal profession, which the IBA president spoke about. And he said that these findings were from 6,980 respondents from 135 countries. And he talked about bullying and sexual harassment. But for that of Nigeria, he says, Nigeria had one of the highest cases. About 50% of respondents had been bullied and 35% sexually harassed.
Yes.
This has got to do with the law profession, isn't it?
Yes.
What is the NBA doing about it? This
Yes. You see, the NBA, when, you know, we are a bit social and religiously, bent. Let me explain to you what I mean. That if there would have been cases, and what you see is that some elders will go and say, please, let's leave up this. Are you with me?
in the legal profession?
Oh, sure. Yeah, the elders
So
will
if
come
that
in.
happens in the NBA...
No, I'm explaining to you. And if the complainant, the law does not run on its own.
On its own.
If the complainant says, I withdraw this, remember, the pressman are taking off that this has happened. But if it says we have resolved it, I
but
withdraw
how do
my
you
complaint.
withdraw a case of sexual harassment when it has happened and you withdraw it?
Oh, sure.
In fact, the report says that some of these
Sure.
targets don't report due to the status of the perpetrator,
Exactly.
fear of repercussion, and the incident being endemic in the workplace.
Sure.
So don't
that's
you think...
that's what we are now talking about. Remember, I told you about public interest now being brought into the fore in the operations of NBA. So you are going to see these statistics change as we march forward.
But, Prof, do you think these stats would have even come up? Would the NBA have raised this if the IBA president had not raised it?
We have that, and we've been raising it. That, we said that section.
Okay.
Yeah, in fact, I should begin by confirming what Leonard Senior Advocate said. There was a strong presence of SPIDEL in this conference, contrary to previous conferences. And quite a number of issues that would otherwise have been lying in the background were brought to the discussion table in this conference. One gives kudos to the management of NBA on that. Now, Leonard Senior Advocate said something that is important. Like the courts will do nothing if people do not file actions before them. What NBA can do and what NBA cannot do is in two folds. First, the former one, that we can do anything at all is that a matter is reported.
Exactly.
Yeah, but Prof, when...
but if that matter is withdrawn by the person who reported...
upon being prevailed upon by elders...
It may not be prevailed in mediation.
NBA will not know why and how. And the person says, well, I withdraw what I wrote earlier.
It could be religious.
I do not also grant witness protection. So perhaps the NBA should look to granting some form of protection.
I'm sorry, my brother. It's in a question of where a person feels strong about his complaint and is being harassed or that comes in. But if I say, well, I've thought deeply, my pastor or somebody spoke to me and all that.
The report does not give that, actually. It talks about being harassed, being,
bullied.
Exactly. So it doesn't say people prevail.
No, you are talking about prosecution. What has NBA done? Goes into what sanctions. You will not sanction in a situation where, remember, there's presumption of innocence beyond this, which is a constitutional point.
Yeah, but that doesn't kick in if they prevail upon the person to withdraw the matter.
That's the point we are making, that no prevail is not...
even be asking them to withdraw the matter?
NBA will not even know why the
NBA may not know.
The NBA will only receive
I'm picking up on what he said.
Don't equate prevail with compel. Doesn't mean the same thing.
But the point, they achieve the same purpose, withdrawing the matter.
If, for example, it could be secular people outside the bar that say, well, please. Because remember, if a lady is going to say, I'm sexually harassed, it's coming to the public, the Nigerian public. What if the lady is not married? If she's married, look at the COSA issue.
We're trying to encourage.
We have to run now.
We're trying to encourage people to speak up about this matter.
Exactly.
So I don't think they should be prevailing on them to withdraw the cases.
The only other thing we can do, which is the second side that NBA can intervene, is what SPIDEL is trying to do now, to sensitize the public.
Yes.
And to assure people that, look, you need to push through these things.
Okay.
It
All
will
right.
depend
We
on the
shouldn't, we
existence
I
of
think we
the
can end on that good note.
we shouldn't be sweeping this on the, under the carpet. That's the point we are making.
All right.
And then,
So I think that point might have been well noted, but I'd like to thank gentlemen for coming on this morning, Mr. Paul and Dr. Paul Ananaba, SAN, and then we also have Professor Richard Wokocha. Thank you, gentlemen, for coming on this morning.
Thank
Well,
you.
that
It's a
is the show today and what a week it's been. We'll see you next week. I'm Chamberlain Uso.
I'm Kayode Okikiolu.
And I'm Malkwe Ogun Yusuf. Have a lovely weekend.
The views and opinions expressed by guests on this program are those of the maker and do not reflect the views, opinions, and endorsement of Channels Television.